You're legally exposed and you just don't know it yet. And I bet you I'm going to prove it to you, because the moment that you end up in litigation against somebody like me, I've got 5 legal powers over your business that most entrepreneurs don't even know exist. I can look through your bank accounts, your emails, your texts, every transaction, every decision, every shortcut you ever took. I get to put it together, my story of it, how recklessly you ran your business, and based on what I've seen over the past 20 years. I'm betting there's a lot you want to hide. I'm Karam Nahas, the battle-tested lawyer, 20 years litigating cases and advising entrepreneurs on business deals. I've used these powers to tear businesses apart, and I've defended entrepreneurs against them. So in this video, I'm showing you the 5 legal powers I have over your business once we're in court, so you understand exactly what you're risking every day that you stay legally exposed. So by the end of this video, you'll know exactly what's coming after you and how to protect yourself before it gets you, right? Let's go. So here's what most people don't understand, what I've learned over 20 years. There are 7 danger zones in business. My entire business defense system is built around mastering those 7. But there's also danger zone 8, and that's the zone you never want to reach. That's the courtroom. And if you fail to protect yourself across the first 7 danger zones, you end up in danger zone 8. That's like going back to jail Monopoly. And understand this, civil court is not criminal court. I don't have to prove anything beyond a reasonable doubt. I just need a preponderance of the evidence. That's only 51%. And all I need to get into court is a good faith basis to make allegations. I don't need proof yet. I don't need facts, just allegations made in good faith. And judges give me a lot of discretion on that, because the entire point in litigation is to discover the facts that we don't really know yet. So once I'm inside, here's what I could do to you. Power number 1 is called subpoenas. I can issue subpoenas that allow me to look into everything inside your business. And I'm not talking about the subpoenas you see issued to politicians. They get a subpoena to testify at some hearing, they claim the 5th, nothing happens, they ignore it, they delay, they lawyer up, and they stall forever. These are not the same kinds of subpoenas. These subpoenas you have to comply with. And if you don't, you lose your case. The judge sanctions you. They can enter a default judgment against you, and it's game over. I can subpoena your bank records, your business and your personal records, your tax records, your QuickBooks, your Stripe account, your PayPal, your Venmo, your ChatGPT chat. I can subpoena your emails, your text messages, your DMs, your Slack, your internal communications. I can subpoena your contracts with every client, your marketing materials, your testimonials, the data behind every claim you've ever made. And if you don't have that, you're shit out of luck. Your entire business, every decision, every transaction, every shortcut you took is open for inspection. And here's the thing, so much of what's inside of there you want to hide. I know you do. Every entrepreneur does. You can't claim the 5th. And listen, if you want to fight me on it, go ahead. Hire a lawyer, file a motion to quash. That's about $5,000 per motion you're going to pay to go into court and have your lawyer argue some BS about why your records aren't discoverable, why they're not relevant, why they're privileged, whatever. And they're most likely going to lose, because this is discovery. Judges want the facts to come out. That's the whole point of it. So think about how expensive that gets for you. $5,000 is a deal, right? You're going to spend thousands of dollars just to try to keep me out of your records. And I'm still going to get in. And what I do, I'm going to build my case against you with documents, or your lack of them. Now, power number 2 is extremely powerful. It's depositions. A deposition means I get to put you under oath and ask you questions for hours, and you have to answer. And this isn't a casual conversation. This is adversarial. It's recorded, it's transcribed, and it gets heated. I got into a fight one of my first depositions. One of the defendants in the case stood up and threatened me with violence. I'm not joking. Right there in the conference room. And that's not as unusual as you think, because think about what a deposition actually is. It's scarier than the courtroom. You've got parties who spent years hating each other, sending nasty letters, filing motions, threatening each other, racking up legal bills. And this is the first time you get to all sit down together in one room, face to face. Who ever thought that was a good idea? I get to ask you about every claim you've ever made in your business, every promise in your marketing, every testimonial on your website, everything really in your books. What objective data did you have to support the income claims that you're promising people? Where's the documentation for all these testimonials? Walk me through how you calculated that ROI. And you have to answer everything under oath. And that expensive lawyer sitting next to you, your lawyer, they can object. But here's the thing, there's really no meaningful objection in the deposition. They can say objection on the record, but they can't stop me from asking and you from answering unless it's privilege. They can't coach you. You're sitting there powerless. There's no judge there to protect you. And that's the reality of a deposition. It's so powerful. I did a whole video about it. I've sat across from business owners who thought that they were prepared, and you're never prepared. They weren't. I've done this for like 20 years. I know how to ask questions that expose the gaps, inconsistencies, the things you forgot that you said, the things you wished you hadn't put in writing. And you're never prepared for those questions. So by the end of the deposition, I've got you on the record. And I'm using every single word against you. Now pay attention, because this is where it shifts from being uncomfortable to completely devastating. Here's power number 3. Injunctions. I can go directly into equity court of chancery. I can get an injunction against you, and I have. I've gotten injunctions and I've defended against them. I know both sides of this. An injunction means that the court orders you to stop doing something or to do something. You have to take an act or stop taking an act. And if you violate it, you're held in contempt, fines, maybe even jail. I can freeze your assets, your bank accounts, your ability to move money, gone. I can freeze your business operations. I can stop you from selling. I can stop you from marketing. I can stop you from operating. I can freeze you from soliciting clients, from using confidential information, from contacting certain people. And I've done that and I've defended it. Just imagine the power of that. One day you're running the business and literally the next day I'm in court and the judge has an order that says you can't run your business anymore. And here's what makes that so terrifying. These are called emergent applications I file before the court. It's order to show cause. Sometimes I can get to court and file this order to show cause without you even knowing. I can prepare my case. I can put together my expert. I can go before the judge. And the first time you hear about this is when I send you the order. You got to show up to court in like a couple of days. You got to go get yourself an expensive lawyer. You got to fight this. I've already studied your case. I've already put together my argument. I'm ahead of you. I've already got my application before the judge that's certified that you're committing fraud. You're playing catch up from day one. Now, the judge has massive discretion in equity court. They can do almost anything. They can freeze your accounts, appoint someone to oversee your business, put in a receiver, order you to preserve documents, order you to stop advertising. And remember, I just need to show a preponderance of the evidence. And in the case of an order to show cause, I got to show irreparable harm, that it's likely for me to win, and that the law is well settled. If this is starting to wake you up, subscribe to the channel, hit the like button, drop me a comment if you've ever been through any litigation like this. And frankly, I like chancery court because, like I said, judges have a lot of discretions and they can do a lot of things inside your business, such as power number 4. What I can do is appoint people inside of your business to basically take it over. Receivers, constructive trust. This is where it gets really ugly. I can ask the court to appoint a receiver. That's a third party, usually a lawyer or accountant, who comes into your business and takes it over. There's nothing you can do about it. And they're not working for you. They're working for the court system. Their job is to protect assets, preserve evidence, make sure nothing disappears while the litigation plays out. That could be years. A receiver can access all your accounts, all your records, all your operations. They act on your behalf. They can make decisions about your business. They can sell your assets. They can shut down operations. You built this business, but it's not yours anymore. And now a stranger appointed by the court is running it. And don't ever forget it. You're paying for this receiver, this partner the court just put into your business. You're footing the bill. You're paying for someone to come in, scrutinize everything you built and destroy you from the inside out, to audit every decision you've made. And there's no way you're going to stop them. It happened to one of my clients. Now think about a constructive trust. It's the same idea applied to your assets. The court says these assets don't belong to you anymore. They belong to a trust for the benefit of someone else, and we'll figure that out later. Your money, your property held for someone else because the court decided you can't be trusted with it. Now, this happens when I convince the judge that you might destroy evidence in my order to show cause, and you might hide assets, and you might flee. And based on what I've seen in most businesses, I can make that argument pretty easily, and you're going to have to rebut it. Now, this last power is the one that you can't escape. Even in bankruptcy, this is the one that's really, really troublesome. This is the one that could really end the game. Now, let's say I win and I get a money judgment against you. Now, that means that the court orders you to pay. And if you don't pay voluntarily, I can garnish your wages, I can put you through collection, I can put liens on your property, I can start seizing assets, things like that. But here's the real kicker. If that judgment is based on fraud, which I love to go after, you can't discharge it in bankruptcy. Most debts, if things get bad enough, you can file bankruptcy, get rid of the debt, and you get a fresh start. For fraud judgments, they stick with you forever. That's why I say fraud is forever, and you can't escape them. And if things are really bad, if I've uncovered serious fraud, criminal conduct, tax evasion, I can ask the court for a criminal referral. I've done that. That means the case gets sent to the prosecutor's office. Now you're not just dealing with a civil lawsuit or civil liability. You're looking at possible criminal charges. Now, civil court can become the doorway into criminal court. And it all started because you were legally exposed and you didn't know it and you didn't know how to take care of it and you wanted to go to litigation. So here's why I'm telling you all of this and why it's so important. I've had the power to intimately see what's inside most businesses, a lot of businesses, much more than you have. And you know what I found? The same thing. Every time, really. It's a huge mess. Nearly every entrepreneur I've seen was making a legal mistake. They were exposed across 7 danger zones. Most of them knew it, but didn't want to know it. You know what I mean? They thought they'd deal with it later. They thought it wouldn't happen to them. They were just going to fly by in their parachute and see what happens. They thought their LLC filing was enough to protect them. It's not. And if you bring any business under scrutiny, real scrutiny, litigation scrutiny I'm talking about, you're going to find violations, gaps, exposure. That's what we do. I would bet on it every single time. And that's why Danger Zone 8 exists, the courts. It's the one place you never want to reach. My entire system is designed to keep you out of Danger Zone 8. Where the court and a vicious litigation attorney like I used to be could literally take over your business with the powers that they get in a civil court or in a chancery court. Now, I told you that you're legally exposed and you just don't know it yet. So now you know the 5 powers I have over your business if we go to court. So the question is, what are you going to do about it? So if this opened up your eyes, hit the subscribe button. Drop me a comment if you've ever been through a deposition or ever been subpoenaed. I literally read everyone. And listen, take the free risk report that I offer. It's 5 minutes. It shows you exactly where you're exposed across all 7 danger zones, across all 5 enemies. I'd rather have you find the holes now than discover them later in a deposition or through subpoenas. The whole point of this is not to scare you. The whole point of this is to prepare you, because remember, defense wins business championships. I'm Karam Nahas, the battle-tested lawyer. Your job is to stay legally bulletproof.